Why do attorneys use CRAC? And what exactly is CRAC? Let's first discuss what CRAC is. It is the acronym CRAC, which stands for Conclusion, Rule, Application or Analysis, and Conclusion. CRAC, or CRAC, has been taught to lawyers and attorneys for many years and is often thought of as the four-step winning formula to argue a case in court. Using this simple principle, you can easily win arguments in court, on the job, or even at home. I will go over each of the steps in detail. Then I will give some examples of how it is used in court with full case scenarios. The first step is the conclusion, the first C in the CRAC method. The attorney simply starts by stating the conclusion or what they are trying to prove in their argument. In doing this, they provide a clear statement of the legal position or outcome the attorney believes is the correct one for the judge, jury, or whomever to also believe at the end of the argument. The rule is part two. This is where the attorney outlines the relevant law or rule that applies to the case. This would include statutes, regulations, or precedents set by case law that are pertinent to the case at hand. Thirdly, we have application or analysis. In this step, the attorney applies the law to the specific facts of the case. They would analyze how the facts support or don't support the rule as it is interpreted. This is where the bulk of the argument will be, showing how the law should be understood in the context of the case's particular circumstances. Then we end with a conclusion by summarizing the argument and reinforcing how the application of the rule to the facts leads to the initial conclusion. This video is sponsored by OREP Insurance and Working PI Magazine. OREP is a leading provider of private investigator liability insurance. Visit orep.org for a quote today. As you can see, using the CRAC method helps ensure that legal arguments are clear and logical. It also ensures that the attorney can effectively tell the court what they're going to prove, shows the legal basis for their argument, applies that legal basis to the facts at hand, and then wraps it up by reinforcing their initial assertion. CRAC is a persuasive way of speaking, or even writing for that matter, that is widely taught in law schools and used in various forms of legal writing and courtroom advocacy. Here is a hypothetical criminal defense case where an attorney uses the CRAC method to present their argument in court. The case involves a defendant. We will call him John Smith, a 25-year-old college student who was charged with possession of a controlled substance, cocaine, following a search of his dorm room. The attorney's argument might look something like this. First, the attorney's conclusion is that there was a violation of John's Fourth Amendment rights due to an unlawful search and seizure, rendering the evidence of cocaine inadmissible. The attorney then cites the rule, the Fourth Amendment protection against unreasonable searches and seizures, emphasizing that evidence obtained in violation of this right should be excluded under the exclusionary rule. In the application analysis phase, the attorney presents evidence that the search of John's dorm room was conducted without a warrant and without his consent, thereby violating his Fourth Amendment rights. The attorney further argues that the police lacked probable cause to search John's room and that no exigent circumstances justified a warrantless search. Then the attorney challenged the reliability of the informant who allegedly tipped off the police about the drugs in John's room, arguing that the information was insufficient to establish probable cause for the search. The attorney also highlights that the arresting officers did not correctly inform John of his Miranda rights, casting doubt on the validity of statements or admissions made during the search. Then the attorney moves into the final conclusion, where he summarizes the case. Here, the attorney reiterates the violation of John's Fourth Amendment rights, the lack of legal basis for the search, and the unreliability of the evidence obtained. The attorney contends that the evidence of cocaine should be excluded and the charges against John should be dismissed. Throughout the presentation, the attorney constructed a clear and persuasive argument that focused on the legal violations committed during the search and the application of Fourth Amendment protections to the specific facts of the case. In a moment, I will go over some of the key things not to do while arguing a case as well. Here is another hypothetical criminal defense case where an attorney uses the CRAC method to present evidence in court. This case involves a defendant. We will call her Sarah Johnson, a 35-year-old business executive who is charged with embezzlement from her employer. The attorney's initial conclusion is that there is reasonable doubt about Sarah's guilt given the lack of direct evidence linking her to the embezzlement. The attorney then highlights the rule, which is the principle of innocent until proven guilty, and stresses the burden of proof resting on the prosecution to establish Sarah's guilt beyond a reasonable doubt. The attorney then moves to the application analysis step and points out inconsistencies in the financial records provided by the prosecution, arguing that the discrepancies do not conclusively prove embezzlement or establish Sarah as the culprit. The attorney also presents evidence of Sarah's positive performance reviews, testimonials from colleagues, and her lack of financial distress as indicators that she had no motive to embezzle funds. Then the attorney challenges the credibility of key witnesses presented by the prosecution, highlighting conflicting accounts and potential biases that could cast doubt on their testimony. The attorney also introduces expert testimony on accounting practices to raise doubts about the accuracy and reliability of the financial evidence presented by the prosecution. In wrapping up the case and moving into the final conclusion, the attorney emphasizes the absence of direct evidence linking Sarah to the embezzlement, the lack of motive or financial incentive, and the uncertainties surrounding the prosecution's case. The attorney asserts that the evidence presented by the prosecution falls short of proving Sarah's guilt beyond a reasonable doubt, and she should be acquitted of the charges. Now, when using the CRAC method, you must avoid these major pitfalls which many people fall into and can be detrimental to your argument. The first is disregarding counter arguments. It is crucial not to overlook or downplay potential counter arguments the opposing party may raise. Ignoring or dismissing contrary evidence or interpretations weakens the argument and leaves it vulnerable to challenges. You must anticipate opposing viewpoints and proactively address them with the CRAC framework to strengthen your case. You also need to ensure you do not fail to tie evidence to legal principles. An essential aspect of the CRAC method is connecting the presented evidence to relevant legal rules and principles. It is vital not to present evidence in isolation without clearly demonstrating how it supports the legal argument being made. Failing to establish this link will weaken your overall argument and diminish the persuasiveness of the argument. You also need to make sure you do not rely solely on facts without analysis. Simply presenting a list of facts or evidence without a thoughtful legal or logical analysis can hinder your ability to apply the rule to the specific case at hand effectively. Do not assume that the judge or jury will automatically draw the intended legal conclusions from the presented evidence. This is why you should provide a comprehensive analysis that explains how the evidence supports the legal argument, emphasizing the relevance and implications of the facts presented. The most important not to do thing involving any argument is not to let your emotions get in the way of the logic of the argument. Anger, frustration, and other negative emotions will negatively affect almost all arguments, thus leading to a less desirable outcome in most cases.